Hello and welcome to this Maritime London webinar in partnership with Ince. I'm Standerwick, Chief Executive of Maritime London. 2 weeks ago, Russia began an invasion in Ukraine. This military action, the most significant we've seen on the continent of Europe in over a generation, has engendered an unprecedented and unified response from the democratic world. From the US to Japan, wide-reaching sanctions have been announced and are intensifying as the conflict in Ukraine also sadly intensifies. While Maritime London condemned the war and endorsed the measures currently being constituted to end hostilities, we cannot ignore the effect the war and subsequent sanctions are having on the shipping industry. Therefore, we have worked quickly with our partners on this webinar to put together an excellent panel to discuss the immediate implications for the sector. This webinar will explore the current status of the sanction response against Russia, with a focus on UK, US and EU sanctions, how the sanctions have affected the shipping industry, with a particular focus on war and P&I cover, and we'll also touch on how finance markets are reacting to the newly placed sanctions. Of course, this is a changing landscape, and we will not be able to cover all aspects off in this webinar. So I expect Maritime London will follow up on today's proceedings with further briefings in the near future. This is a live and interactive webinar, and we encourage all of you to engage in both the chat and the Q&A functions, and we will do our best to cover off as many questions as we can. As you all know, things can go wrong, and we're just waiting for one of our panelists to join us, who will be there very shortly, but do bear with us if we experience any technical problems. Lastly, this webinar is being recorded and will be uploaded to our YouTube channel after the event. But for now, I'd like to pass over to Stuart McAlpine from Ince, who will moderate today's session. Stuart, over to you, and thanks very much.
Thank you very much, Joss, and hello everybody, wherever you are. Welcome to this seminar, so expertly introduced by Joss. I'm Stuart McAlpine from Ince in the Marine Finance and Projects Group, and I'm joined today, I'll moderate this session, and I'm joined today by a number of people, one still to arrive, but he will be here soon, I'm sure. Those currently with us are Andrew Jacobson, a US sanctions expert from the New York-based law firm of Seward and Kissel, James Rose, a UK sanctions expert from our own firm here in London, and Julian Clark, who to many of you probably needs no introduction, a sanctions expert and our global senior partner. We're also going to be joined by Mike Salthouse. He is en route. He's a global director of claims for the North P&I. He had some tech issues a few minutes ago, but is herring his way up Lloyd's Avenue as I speak, I hope. As Joss said, we would like this to be very interactive on the Q&A. Use the chat, use the Q&A. I think if there are questions, maybe helpful to use the Q&A section rather than the chat, so I can pick them up. And we'll try to deal with them as we're going along and try to put them in some sort of sensible order. So I'll do that. Just as a sort of a signpost through the next hour or so, what I thought we'd do is start with from a legal aspect of the war implications of what we're seeing unfold in Ukraine at the moment, and Julian will take those questions. And then depending on whether Mike arrives in time or not, we might go to P&I next, and then sanctions third, dealt with by Andrew and James. But let's see what time Mike arrives. So without further ado, and in order to kick this off, this is a question for Julian. And really the thrust is, Julian, whether the current situation in Ukraine falls within the legal definition of war, and if it does that trigger automatic termination provisions, the Common War Clause and so on. So could we kick off with that, Julian?
Absolutely, Stuart, and again, my greetings to everybody wherever you may be in the world watching this webinar. It might be a strange question in some ways, to ask whether or not what we're seeing happening in Ukraine is war. Obviously, as a man on the streets interpretation of that, of course it's war. But what is the position as a matter of law? English law, and there have been lots of debates, quite interesting academic legal debates over the years as to what comes within the definition of war. My career and expertise in this area started just after 9/11 and the case that went to the Court of Appeal, If and Silversea, about whether the acts of 9/11 were an act of war. And that all revolves around a case called Spinney's case, which is still the legal authority. But I can say we don't need to worry about any of that in relation to what's happening in Ukraine. It is clearly, as a matter of English law, an act of war. So there's the first answer. Second answer, or second question, does that trigger the automatic termination provisions? And this is something that certainly we at Ince, and I'm sure lots of other people out there have had members, assureds, clients, customers, calling them to ask whether or not this is so far an automatic termination event. The answer to that is it depends what it says on the can, and the can in this case is whatever contract you're operating under. Generally, the war termination clauses, so if you look at, for example, at the ones in the whole risk policies, they only create automatic termination events where it's war between a certain named list of major countries, and that was normally will be China, England, France, the USA, Russia. So we don't have an automatic termination position at the moment because this is currently a war between Russia and Ukraine. The next question that comes off on that is, well, what if NATO become involved? What if the UN do go in to Ukraine? Does that make it a war between Russia and NATO or Russia and the UN? Again, answer no, because in the normal operation of the UN and any peacekeeping force, they are doing that. They're there as a peacekeeping force. Were it to be the position that there was actual military intervention, and this is all around that no-fly zone question, that would potentially trigger a war between Russia and Ukraine, and then you would be looking at the automatic termination provisions. Third question, Stuart, was, well, what about things like the con-war clause? And they are far wider. That clause is far wider. It talks about war, but it also talks about acts in relation to warlike operations. Again, I think we almost certainly are now within a position where the con-war clause would apply. So that's my answer to that first question, Stuart.
Thanks, Julian. And then you know, moving on and thinking about the contractual situation a bit more. So, are we in a situation, in your view, where contracts are at the point now of being deemed frustrated due to the current situation, or is this more a force majeure event? What's your view on that?
Thanks, Stuart. And again, I think that's a question that many of the people on this webinar will be asking themselves and have no doubt been asked by customers, clients, members, assureds. Let's separate the two distinct options there. First of all, frustration. Secondly, force majeure. Force majeure is not a concept of English law. So there is not a defined position in relation to statute or common law regarding force majeure. Force majeure is a contractual arrangement. And again, I come back to this thing about it. It's what it says on the can, but the can in this case is the contract to the contractual clause. So depending on what that clause says, this very well could now be a force majeure event. The important thing to remember about force majeure clauses, and for example, the most popular one in shipping, the BIMCO clause, is that there's also a proviso. And the proviso that's the introduction to the clause, I'm doing this from memory, unfortunately, so I can't give you the exact wording, but it's basically whether or not the event can be avoided by reasonable means. So just because a contract becomes more expensive, more costly, more difficult to perform, doesn't automatically mean the force majeure will apply. But if it's not possible to evade the consequences of the situation which is then set out in the force majeure clause. So, for example, let's take an extreme example like every force majeure clause talks about acts of God and earthquake. If it's an act of God or it's an earthquake and you can't reasonably evade the consequences, that triggers the force majeure clause. If the force majeure clause has a war provision in it, so it uses war as an event, and again, if you can't evade the consequences by reasonable means, that almost certainly does now trigger the force majeure provision. Let's park that one and talk about frustration. Frustration is an English law concept, but English law doesn't like frustration very much. If you look at all the authorities over the past 20, 30 years, you've seen a narrowing down of the court's willingness to allow a party to extricate themselves from a contract because of a open, close quote, frustration event. And the thing to remember there is effectively frustration, the frustrating event must effectively block or make performance impossible, as opposed to an attempt to rely on frustration as an excuse to get out of the contract. So the answer to whether or not frustration has a part to play in relation to the current situation in Ukraine depends very much on the circumstances of the contract. If it truly looks like it's impossible to perform, it might be a frustrating event. So let's say you had a contract that was limited to load one cargo at one Ukrainian port, and now that port is no longer operating. There are no cargoes there, and perhaps the port's even been overcome by Russian forces. I'd say that probably now is a frustrating event. But of course, if the contract's wider and gives a permission to load other cargoes from other ports, then if there's an alternative means of performing, that will not be frustrating, even though that might end up being more expensive. Stuart, thanks.
Thanks, Julian. So as you know, as ever, many of these questions will be determined by a close and rigorous analysis of the relevant contracts. So, I mean, to the extent that anybody watching, listening to this has questions on the war aspect, you know, please put that in the Q&A, and we'll put those questions to Julian. So what I'm going to do now, I'm going to move on, if I may, immediately and start talking about the sanctions scenario, if I can describe them as such. And I think, James, I'm going to come to you first, and I'm going to ask you really just to give us an overview of the recent UK, and to the extent that you can, EU sanctions which have impacted shipping. I mean, I know that's a big job to do in a relatively short period of time, and apologies for that. But if you can sort of make an attempt at bringing that all together for us, I think I know I'd be very grateful, and I'm sure everybody watching would be too. So can I pass that over to you, James?
Yep, that's fine. Thanks, Stuart, and hello to everyone to watching this. Just to take a step back, sanctions are not new over the last few weeks. The UK and EU have had for a number of years had sanctions on Russia and Crimea following the events in Crimea in 2014, and the past sanctions over the last 8 years or so have targeted certain persons, so that's sanctioned persons, restricted various business with Crimea, and targeted the Russian energy industry, so that's exploration and deep water projects. Following the recent events, we've obviously seen a significant ramping up in the sanctions and widening of scope, and I'll provide a summary of these in shortly, but it's just worth taking a step back because there's a lot of press that's going on there about what the sanctions are, what might be introduced, but that there has to be a legal basis for the sanctions that come into play. And if you look at the EU position, the sanctions are generally imposed via EU regulations, and these require the agreement of all the 27 EU member states. So it's important that when we're looking at what is the sanctions in place, you look at the right regulations, you look at the legislation, because it's very easy to get carried away with the press as to what restrictions are being imposed. And following the UK's departure from the EU at the end of 2019, the UK has its own power now to make its own sanctions and legislation. And at the time of the UK departure, the EU sanctions were adopted into UK law by the Russia Sanctions EU Exit Regulations 2019. And I'm not going to go into all the specific sections of those sanctions because it'll be fairly boring and we haven't got the time to do so. But the consensus at the moment, there is a possibility that the UK could go diverge from the EU, and I'm sure Andrew will come on to the US side. But at the moment, at the current time, the UK appears to be working in conjunction with its US and EU partners so that the sanctions landscape, so to speak, should be all towing the same line. But that can obviously change. So if I just look at the trying to combine the UK and EU position, there's been a ramping up on the people whose assets are frozen. A number of people have been targeted, so a lot of oligarchs linked to the regime in Russia. A lot of banks have been targeted. One, for example, is VTB, who've been heavily targeted, and also those companies that are in the defense industry in Russia. So from what we had as a fairly limited list, there's now a lot wider list, and the anticipation is that more people will be added to that list going forward. And it's worth pointing out that the UK has also been criticised for not going quickly enough in designating persons that the EU and perhaps the US has. And at the moment, there's a bill going through Parliament to allow the UK to act more quickly than it has been in sanctioning individuals who are designated by either the US or EU. So, as I say, it's worth checking the lists because sometimes they won't be sanctioned by the UK, but might be sanctioned by the EU, or again, might not be sanctioned by the UK and EU and might be sanctioned by the US. So there's this whole web of sanctioned persons involved. And then in addition, we've seen bans on restricted technology to Russia and persons connected with Russia. So that includes some equipment in the aviation and marine industry. We've also included an increase on the banking exclusions, which relate to transferable securities and money market instruments, loans and credits to certain Russian sectors and people. And then of significance over the last week or so from the UK perspective, and where the UK has diverged from the EU, is where the UK has imposed a ban on Russian-owned, controlled, chartered or operated vessels from calling at UK ports. So for the purpose of the UK regulation, this includes owned vessels, so that's those with legal title to the ship or any share in the ship who may be Russian or beneficial interest in that ship, or indeed controlled, where a person who is able to take decisions about that operation, including but not limited to decisions about the route the ship may take and the appointment of master or crew. So this can be fairly wide restrictions, and we've already seen it having an impact on vessels that may be due to call at the UK that are owned or controlled by Russian interests. And the EU Parliament, as I said, this is why it's important to understand the legislation. The EU Parliament has put forward a resolution which is calling on the EU to impose a similar ban on Russian vessels, and also goes further to say that they were looking to stop vessels whose previous or next port of call is Russia. And this is a much wider restriction we've seen from the UK so far, and it hasn't yet been adopted by the EU Council and Commission, and so it remains to be seen how far the EU will go. But there have been indications that a potential Russian ship ban will come into the EU later this week. So it's to watch this space at the moment, I think, on where the sanctions are going. And I would flag at the moment, there obviously the press is reporting about the EU and the UK, etc., putting in a ban on Russian oil and gas. There is not as yet a ban on Russian oil and gas supplies being shipped from Russia. But as I say, you still need to check the sanctioned persons who you're dealing with on all of those transports, so that the cargo itself may be fine, but you've got to look at who you're dealing with in Russia. So it's a slightly whistle-stop tour of where we are at the moment, but it's changing, as I say, day by day at the moment.
Thanks very much indeed, James. Hope you can hear me. And I'm joined now, as you can see, hopefully everybody, by Mike Salthouse, Global Director of Claims for the North P&I. And Mike, thanks for making it. I know you had some tech problems earlier on. James, thanks for that. You touched upon the UK government's decision to exclude Russian vessels from UK ports. And one of our guests has asked how viable that is. I don't know to what extent you can comment on that, given the sort of fairly recent announcement of this measure. But do you have a view on that?
I think there is action. I don't know what the government may be saying to the individual port authorities at this time, but from what I understand, there will be action taken, and we have seen vessels stopping to call in UK ports. I mean, there is a legal issue of vessels being stopped under the legislation, but there is also a practical issue that we've seen and reported in the UK press, where dock workers at certain ports in the UK have been, and this goes wider than the legislation, have been refusing to discharge Russian cargoes. So there is a practical issue of, can your vessel get into the port, and the legal question of, is it permitted to? And I think there are, as it only came in last week, I think there'll be a grappling with working out what vessels are owned, control or chartered, because it's not always clear what the beneficial interest is on vessels coming into the country, particularly if you've got a long charter party chain and lots of different people involved. All those interests in jurisdictions where they may not, the beneficial shareholding may not be known. But I think there will be an active, as I understand it more widely, there is a task force, or the governments in the UK and then the EU and the US are all looking to find out where these vessels are and inform people of the issues. But I think we'll see more of it over the next couple of weeks as cargoes get towards the UK, or if it comes into the EU, get towards the EU.
Brilliant. Thank you, James. Just before I move on to Andrew, there's a question here in the Q&A, which I'm going to put to you, James. This may be something that will need to be taken offline because it's very specific, and it's a request that the panel comments on the impact of regulations 28.1 and 3 of the Russia sanctions EU exit regulations 2019, and the ability of insurers and brokers to provide financial services to, and I quote, persons connected with Russia, unquote. It's very specific reference to those regs. I put it on the basis that you might be able to comment, but you might not, and you might need to look at that offline. But what do you say to that, James?
I think if it's the regulation I think it's dealing with, the general concern, I think, is that financial services in its definition under the regulations, or generally speaking, does include insurance services. So if there are restrictions under the sanctions which refer to financial services, they can encompass insurance services. And it would be important to look at exactly what that insurance is covering and what the restrictions are in place, because it's not, there isn't a blanket ban on all Russian trade at the moment. So if there is a question on insurance, it's what are the restrictions preventing an insurer from doing? So is it a certain good or technology that it's looking to ban, or is it insurance to a sanctioned person? Those are kind of the issues that you need to be looking at. But it's certainly a point that needs addressing. If there's a concern, it's important just to look back at the legislation and see what is said. I haven't got them all to hand at the moment to go through the individual sections, unfortunately. But those would be the points that I'd be thinking about.
That's helpful, and I hope that's helpful for the person who asked the question. Thank you for the question. So, and thanks for that overview of the UK and the EU side of things. So, Andrew, if we can turn to you now and maybe ask you to do something similar, but from a US perspective.
Sure, happy to, and thanks for having me. Great to be here. I think to James' point, the U.S. sanctions against Russia are not new. They've been in place since 2014, and they've largely been sectoral based, so focused on certain sectors of the Russian economy, including the financial services, defense, and energy sectors. I think over the past 2 weeks, the U.S. obviously substantially increased and expanded its sanctions against Russia. There still is not a full trade embargo. There's not a full transaction ban with the territory of Russia. So there's a lot of news articles right now that say Russia is the most sanctioned, jurisdiction from a U.S. perspective. It's really not true. Russia is not treated like Iran, North Korea, Cuba, or Syria or other nations. However, it could be going down that path. So what has happened over the past 2 weeks? There have been several things. The U.S. has largely focused its new sanctions on Russia's financial services sector, really with a target on Russian state-owned banks and other types of financial institutions. So the U.S. has sanctioned, meaning put several Russian banks on its SDN list, which is the specially designated nationals and block persons list. That list reflects a full transaction ban as well as asset freezing requirements. The U.S. has also imposed restrictions on new debt or equity issuances of certain Russian companies. It has imposed restrictions on dealings and new issuances of Russian sovereign debt. And I think importantly, the U.S. has imposed a transaction ban, but not asset freezing on the central bank of Russia, which has posed a pretty tremendous challenge for clients seeking to perform foreign exchange transactions, whether it's U.S. dollar, ruble, euro, ruble, etc. The central bank of Russia is not allowed to be a direct or indirect counterparty to really any transactions, subject to some certain limited exceptions. Similar to the UK and the EU, the US has imposed pretty wide-ranging oligarch sanctions. I would say we're actually a little bit behind those in Western Europe in terms of oligarch sanctions. We just announced ours at the end of last week, and they targeted, oligarchs, their families, because oftentimes family members of oligarchs are used, to park assets and are served as, beneficiaries of trusts, etc. Numerous yachts as well as aircraft were designated. Interesting in the U.S., a vessel, aircraft can actually be put on the SDN list. It's pretty unique to U.S. sanctions. And I think finally, one thing that we're looking at for pretty closely is the impact on the energy sector. The U.S. has specifically excluded energy from all of these sanctions, subject to certain limitations. There's been rumors that today the U.S. will be announcing a ban on imports of Russian oil and other, petroleum products. So, it remains to be seen if that ban is announced and what the frameworks of that ban is.
Thank you very much, indeed, Andrew. And there are some questions coming in, and I think what I'll do is pause and take them, and it may be that we'll sort of backtrack a bit. So forgive me for that, but I just want to make sure that we give some airtime to these questions. One was a question about what a ship owner or a manager who time charters his vessels to liner operators without issuing his own bills of lading would be expected to scan in terms of sanctions checks. Can he rely on the checks of the liner operator, or does he need to scan cargo interests himself too? So I don't know. Julian, do you want to maybe have a first crack at that?
Yeah, sure, Stuart. I think the answer to that is for some time now, probably since the time when the US started to really look at enforcing the application of secondary sanctions, that there is nowhere to hide in relation to your obligations of regulatory compliance. And we've seen a lot of people say to us, well, I'm a broker. I'm not really directly involved in this. Obviously, I've done a check on my direct client, but is that enough? My advice to anybody out there is when you look at the wide-ranging effects of what a sanctions application can do. So take as an example what happened with PB tankers, where one vessel had contravened, although in a way legally, they were on a valid legal contract at the time. One vessel had traded to Venezuela, but the effect of that was that the entire fleet was put on the sanctions list. That included one vessel where PB Tankers didn't own it. They managed it, and it was an FPSO, so it couldn't even trade. But it extended then to suppliers of services, to legal advisors, to insurers, to brokers, you name it. So my answer to that question would be, yes, you do. You should check, and you should be able to demonstrate your own due diligence just to make sure that you don't find yourself, whether you're one step in the chain down, 2 steps, 3 steps, 5 steps, 8 steps. There's just no way that anybody could come to you and say, what due diligence did you carry out? And the only answer you can give is, well, I didn't really. I was just relying on the parties up the line. I think it's really important for everybody to now have a system for carrying out those checks. And there's various ways in which you can do that. And I can go into that either later in this webinar or offline, if that's easier.
That's helpful, Julian. Thank you. There's another question here, which I think is probably also for you, actually, Julian, which is this. Are there any searching tools which includes entities and persons named by recent sanctions regulations. And the person who asked this question is, asking for information about these searching tools, US, EU, UN. And, of course there are, right?
There are, and actually what I'd say to that is I'd go back to something that I think James said when he was speaking, which was, for me was incredibly valid, which is you've got to be very careful what you read and what you rely on at the moment. We were asked by a client of ours yesterday, have we got a problem? Because we've just seen that this contracting party of ours has been listed. But they hadn't, they had been listed on a list of a think tank, but that wasn't an official list, but it was on the internet. And if you Googled, sanctioned people, that's where they found this list. It meant nothing at all. It's just what the think tank had decided. So the answer is the OFAC list, the EU list, the OFSI list in the UK, they're all accessible by a pretty straightforward Google search. So that's the easy answer to where you find the list. But my very, very, very strong recommendation is sanctions stuff is really complicated. And it's not just about finding the entry on the list, it's understanding what that means. And for that, my recommendation would be to come to your professional advisors. So either your club, to an expert like Mike, or to ourselves, or to your law firm that has a sanctions capability. And again, I'd be selective because sanctions is a very specialized area. And you need to be talking to somebody that does have proper expertise in the field. So I'd really recommend that. And then finally, there are tools available that help with risk analysis, and one of those that we work very closely with, but I know so do other major operators and some of the clubs, is a facility operated by Winwood, an Israeli firm that have a data analytics system, and they've just made that accessible to everybody free of charge for the next 2 weeks. Normally that's a paid for service, but if you go onto either the Ince website or the Winwood website at the moment, you can get access to that data analytics system. So that's something else to bear in mind.
Thanks, Julian. There's a couple of questions here actually about trading to Russia, and the question is this: is there a risk that any extension of the port ban to preventing Russian-controlled ships from continuing to trade to Russia or elsewhere could be treated by Russia as an act of war? And the questioner says, port entry ban is one thing, but restraint is another. So, Julian, again, I think on the war topic, maybe you could kick off, and if anybody else wants to chip in, I think they should feel free to.
That's a brilliant question. I mean, if I understand it correctly, could the restraint of trade be classified as an act of war? As a matter of English contractual law, no. As a matter of how would, say, President Putin to react to that, well, who knows? One would hope not. One would hope that he'd react to that by saying, well, in that case, I'm going to restrict the acceptance of all foreign vessels to Russia. So no, I think the straightforward answer to that is that itself, that kind of restriction itself, would not be an act of war.
Okay. All right. Thank you very much, Julian. So I think there are lots of questions here, and I'm going to try to sort of come back to them. So let's just for a second, maybe ask the sanctions lawyers. Maybe come back to you, Andrew, first. Just in terms of best practices to consider for compliance and risk mitigation from a US perspective, what would you be counselling at this point in time to your shipping clients?
Sure. I think it's probably a similar approach to what James is going to say. And I think the first is just assessing exposure, assessing your exposure to the Russian economy, assessing exposure, to various chartering and cargo relationships that you have, keeping in mind what are your voyage routes, having another look, I think, as well at, some of the sanctions language in your charter party agreements. To the extent that you're chartering your vessel out to other operators, are those other operators going to be complying with the laws that you, perhaps as a vessel owner, are subject to? So on the one hand, assess exposure, and on the second hand, get a sense of what your compliance program provides for. And if you don't have a compliance program, I think now is a good time to start incorporating that into your business plan, because at the end of the day, if OFAC or other U.S. regulators come knocking, having something written, having something documented in place will do, even if you have a violation, will serve as a mitigating factor in any future enforcement action. So while you want to avoid a violation, you also want to prepare to the extent that something does go wrong out of your control and demonstrate that you did the best you could to prevent it. And I think the last thing is, to the extent that you have financing and other third-party contractual obligations, get a sense of what those contractual requirements state. So, for example, if you're not a U.S. company and jurisdictionally under a strict letter of the law, you're not subject to U.S. sanctions, you're not a U.S. person, etc. That might be true, but you might have signed a financing arrangement with a European bank, with a U.S. bank, with some other third-party insurance company, et cetera, where you've contractually committed to comply with U.S. sanctions. And so, understanding the conflict between your strict letter of the law status versus your contractual obligations, I think is really important at this stage in the game, because, having a default, technical default on your financing by virtue of a transaction that could have easily been avoided, it's just going to create a total mess.
Excellent. Thanks very much, Andrew. James, maybe just same question for you, really.
Yeah, and I think echoing what Andrew said, it's that if you're getting employment orders to deal with Russia now as an owner or charter or wherever you are in the chain, it's about understanding your exposure, because and I have sympathy, because there are a myriad of restrictions across the UK, EU, and US. There's, as Julie was mentioning earlier about looking at the lists, there are people who are sanctioned under the US for financial restrictions, and the same under the EU, that aren't a full, you cannot deal with these people. So it's about understanding what who the parties are in your potential trade and where the risks are going forward. So looking at your sanctions clause, for example, some of the older sanctions clauses don't talk about the UK, because at the time that those clauses were agreed in the Charter, the UK was a part of the EU. So it's about understanding where your risk is, where your nexus is as to what sanctions you may be subject to, and as Andrew pointed out, where the US jurisdiction is, your financing. It's about trying to be proactive as far as you can, because at the moment, if your vessel's calling in a week's time or 2 weeks' time to Russia, you can take a position now, but in 2 weeks' time, the position may be completely different, or there may, more sanctions go in place. So it's just understanding where the risk factors are in your business, I think, is the key.
Thanks, James. Very helpful. Julian, I think you're seeing some questions in the chat that I think you can take. So do you want to pick those up at this point, and then we'll come to Mike?
Yeah, just very, very briefly, and may I start by saying, on any of these questions, if we do run out of time, I know that everybody on this call are very willing to engage. So just if you go to Maritime London and ask them to forward any questions onto the panel will take them. Just picking up on some of the questions that came in, there was a question in the chat about what happens if you're mid-voyage or mid-contract and the entity suddenly gets sanctioned. I was discussing this with ITIC, the Transport Intermediaries Club, this week, and we both formed a view that in those situations where you have a conflicting obligation under, let's say, your existing contract, let's say a SOLAS obligation, and let's say now a sanctions obligation, sanctions probably trumps everything. So sanctions is the one you've got to deal with first. But the good news is that often OFAC, OFSI, the EU will either give a period for the completion of an existing contract. So they'll give there'll be a license for, say, a 30-day period to extricate yourself or get yourself out. Or you can always go to the authorities and say, look, can you give us a permission to complete this voyage, or, complete the supplies to the vessel? So that's the quick answer to that. I think there was another question in the Q&A, which was about war risk termination. It's becoming harder and harder, as many people on this call will know, to obtain war risk cover. and a number of the underwriters have triggered their automatic cancellation provisions. Believe it or not, that's actually created a question under English law which has not yet been addressed. We've taken leading counsel's opinion on it, and it's whether or not the underwriter can just cancel or whether they're obliged to offer terms. Now, whether or not those terms can be acceptable or not is something for the parties, but whether there is at least an obligation to offer some terms. And the answer is we think there is, but that would probably be a case that would find itself in the Court of Appeal or Supreme Court. So again, if you find yourself in that situation, you should let us know or let your lawyers know, your P&I club, and they'll be able to advise you. And then finally, there was a question about what about crew that, you know, maybe say in Ukraine on a vessel that's detained, and they're saying, you know, we want to get off this vessel. And again, that's a situation that we're actually dealing with at the moment in a live case. The answer to that, from a legal point of view, there remain obligations under your insurances to ensure a vessel is manned, and our general advice to that is treat it as if it was, you know, a cold or a warm layup situation. It might mean that you have to find a skeleton crew to stay on board to look after the vessel. The advice that we've been giving to crews in Ukraine as to whether or not they should seek to try to leave Ukraine and get to the border is, in many cases, you're probably the safest place for you at the moment is on board the vessel. But again, it's something where you need urgent advice from your P&I club, from your legal advisor, to just be able to look at the safety of the crew, which is obviously paramount. Thanks, Stuart.
Thanks, Julian. Thanks. So you mentioned advice from the P&I club. So we've got a senior representative of the North here, and again, welcome, Mike, and thanks for your patience. So maybe we could just start with you know, the following question is really how does the war in Ukraine affect P&I cover, put simply?
Yeah, well, first of all, thank you, Stuart. Thank you very much for hosting me. Sorry that I was a little late. I had some technical difficulties, but delighted to be here. So I think the first thing when we're looking at P&I cover is to appreciate that the sanctions actually aren't really directed at shipping and energy at the current time. So whilst there are a few ship owners, Russian ship owners, that have been designated and they have lost their cover, as you would expect, the majority have not. The majority will therefore remain uncovered until those sort of contracts become legally or practically frustrated. The two may even be the same. That applies also to Russian energy cargoes, principally oil and gas. Now, obviously, there's quite a lot going on in the press about this at the moment. But no matter how offensive it might be to us as private citizens, you know, we're acutely aware within the P&I industry that governments have chosen not to target oil and gas, and that they will have done so for a very good reason. It is not for us to second guess that, particularly when we recognise that financial services, not just P&I clubs, have a pretty pivotal role in facilitating such trade. And we're just very reluctant, I think, to move out of step with what our regulators' policy is, and the majority of us in the international group, that's the UK government. All on that point, also, I would also say we do have, you know, over the years we've built up quite mature relationships with governments. That works very well. There are good contacts there, and you know, we recognise the challenges that they've got as they look to implement this sanctions regime. I think in the months before, you know, the Russians invaded Ukraine, there was a lot of speculation as to what was about to happen, and the general view was they would go after Russian banks, and SWIFT was mentioned quite a lot, and also Russian energy. Now, what has actually happened is that they've gone far further in financial services than anybody expected. I mean, they've designated a G20, you know, central bank, for goodness sake. I mean, that's unprecedented, and we've never really seen that before. And the impacts are very, very wide ranging of that. But they've chosen very deliberately not to go after oil and gas. And as I say, no matter how offensive we find that, you know, there are very, very good reasons for that decision, and they are increasingly been played out in the press. So we will tend to follow the law in that. But whilst we do so, I think we also need to probably to talk about a lot of what's coming out in this particular conversation here, which are the indirect effects of these sanctions. And the indirect effects we simply cannot escape from. I mean, let's be quite frank about this. We may legally provide a contract of insurance for a Greek ship owner who has Russian crew on board, but it's going to be very difficult for the Greek owner and to discharge the liability to a Russian crew member who may have suffered an injury, or for us in turn to indemnify that because simply of the wide-ranging sanctions against Russian banks. And when we look also at banks, we need to talk about bank attitude here. I think we're all quite familiar with this. Often not what they are legally obliged to do or not to do that's relevant. It is whether they have the appetite to do it at all. And that's really where these sort of secondary effects of sanctions are really starting to come in and bite our industry. Because the reality is it's very, very difficult now for insurance contracts to function practically, not legally, practically, where there is a Russian nexus to anything at all, because of bank appetite, because of people naturally hesitating, because of the complexity of the economic sanctions that have been introduced and the need to take legal advice from, the other sort of legally qualified members of the panel before you actually make a payment. So my sort of guidances to this is sometimes, and I think this sort of echoes the comment that Julian made, is not really to look at this from a sort of narrow legal perspective. Often it's really just to look at it in the broad, from a broad point of view. If you're doing something with a Russian nexus now, you can expect problems from financial services, insurers, P&I clubs, whatever else. Not through lack of willingness on our part. We support our ship owners as far as we're practically and legally able to do. But practically, it is now very difficult to provide anything like a full service on any sort of Russian nexus claim. Give you an example. You're sailing a large ship, non-Russian ship. You contact a Russian a piece of Russian infrastructure. The club manager is going to have to think very long and hard as to whether they're in a position to provide the security that would normally facilitate the release of that vessel, as we would routinely do. In the same way that we've had these debates with problems where lawful trading has incurred a liability towards an Iranian. The difference with Russia is it's a much larger economy, and that's really what's causing so much difficulty. So it's I suppose to summarise, we're not second-guessing government. We'll support our members in all lawful trades. It's becoming increasingly practically difficult to do anything to support anything with a Russian nexus, because financial services generally are distancing themselves from those sorts of trades.
Thank you, Mike. There is a question up there. Maybe you can see it, about the clubs coming under political pressure to start withdrawing cover on vessels recently fixed to loading or discharging at Russian ports. So I guess really you preempted that by what you said, but can you give a view on which way you think this is going to go?
I think any conversations we have, governments are obviously quite sensitive. All I would say is that there are very mature, well-developed lines of communication with the EU Commission, with the US government, and with HMG, Her Majesty's government. And we're reasonably confident they understand what we do, the significance of what we do, and if they want to discourage us from doing that, then they will legislate, and we will follow the law. And there is, within financial services generally, there is zero risk appetite to break sanctions. It doesn't mean to say occasionally we don't get it wrong, we miss something, but the reality is, if we identify a trade which is unlawful, you won't have cover for it, and we'll follow those directions. And we're pretty confident that there is a sophisticated, informed conversation going on within governments about what they should be doing in relation to Russian energy payments.
Thank you, Mike. And I mean, in terms of the way in which sanctions risks are being managed at the moment, what's changed in the last couple of weeks, or what do you envisage will change as we go through the next 2-3 weeks in terms of managing sanctions risks?
it's a good question. I think what I'd say to that is that actually, we've been managing the sanctions risk for a long time, and it has developed and changed over the years. But I think the clubs are really quite good at it, the basic way in which we do that is obviously we have a suite of rules which excludes trading either that's in breach of sanctions or that puts us at risk of ourselves being in breach of sanctions. We do screen and monitor ship movements and the areas in which we look, and we've got some very good developed relationships with software providers. There's some of them on the webinar this afternoon. We're quite used to dealing at a practical level with sanctions issues, and that means where ships run aground on, for example, islands that are disputed Iranian territory. I guess what springs to mind a few years ago. We've worked through these issues before, and I think the experience level within the marine insurance industry generally is really quite high now. And I think probably the biggest change I've seen over the last few years really is been the maturity now of the relationships with our regulators, which are developed, which do take place. I mean, they're very quick to tell us if they've identified sanctions breaking activity, and we're very quick to tell them if we disagree. But there is that conversation that goes on, and I think that reduces the risks to us as clubs. But it also ensures that unlawful activity is there are other sources of unlawful activity being drawn to our attention, which we will act on. There's no, as I say, there is no appetite at all on the part of marine insurers to break sanctions. So if you're breaking sanctions, you will not enjoy cover.
Thank you, Mike. And speaking as a finance lawyer, I think a lot of the comments you just made in relation to the stance, the position that the clubs is taking is mirrored by the banks. Really, I met yesterday with a senior ship financier with one of the big shipping banks, and he was telling me that in terms of Russian risk, of course, and sanctions compliance, it's absolutely critical that those sanctions are complied with to the letter. But the reality is that even trades which may be possible under the sanctions provisions as they stand currently are probably also not going to be done if they have anything to do with Russia. And there is a general, I think, within the financial services industry, certainly within the commercial banking industry generally, I think risk appetite across the board is reduced. I think underwriting decisions are having to be made now at the very highest levels in these banking institutions, and that's probably only going to become ever more a reality. And I think there are concerns about liquidity. There are concerns about having to allocate additional capital. So the banking market is of course tightening, and we can probably expect that to get tighter and tighter as we go through the next period of time. And I would say that I think Maritime London is thinking of having a separate webinar probably quite soon, focused on the financial aspects of this, maybe financial services, commercial banking. I think the details are still to be worked out. But well, hopefully, ladies and gentlemen, that was helpful. It was pretty much a whistle-stop tour through the legal aspects of this, as far as whether this is a war. We've covered US and UK sanctions, I think quite thoroughly, and also Mike's comments in relation to the P&I world and where it is today and where it might be tomorrow. I think have also been very helpful, certainly as far as I'm concerned. So maybe I can just, Julian, I don't know whether you want to just say a few closing remarks. Pass the baton over to you for a couple of minutes.
Thanks, Stuart. Well, again, thank you to everybody, and thank you, Stuart, for being such a fantastic moderator today. I think we all are aware that as James said, the situation is changing by the day. In fact, often changing by the hour. I've seen some live feeds coming in over the time of this webinar about a new statement from President Biden about further restrictions on the provision of hull cover and war risks cover. So things are changing, and I think no matter what happens, and God willing, there is a swift resolution to the conflict, but the ripples from this pretty large rock that's been dropped in the pool of international commerce are going to continue. I was speaking to a capital markets expert the other day that said that they expect that one of the results of this invasion will be the IPO market will be dead for the next 12 months because, as Stuart was saying, the risk appetite has really changed. And again, as Andrew and James and Mike have all said, we've never seen a sanctions regime applied like this internationally. We've never seen the UK issue a ban on call to ports for vessels that are, not sanctioned, but just connected and operated to. So I think it's going to be a time where we've all got to keep a very strong hand on the tiller. James, anything further from you, and then perhaps we'll have a closing word from Andrew?
No, I think that's right. I did notice, I think, one question about crewing of vessels, just to clarify on the UK ports, that the master and the crew, unless they're designated persons, that doesn't mean that they control the vessel. If they're Russian crew, doesn't mean they control the vessel for the purpose of calling in UK ports. But I'd pick that up because I think I saw it somewhere in the questions before we depart. But yeah, I think nothing else from me.
Thanks, James. And Andrew.
Sure. Thanks, Julian. I would echo, this is unprecedented in U.S. sanctions history. The U.S. has never sanctioned an economy that was so intertwined with the global markets, with North Korea, Iran, Syria, other countries. They were already isolated when they were sanctioned by the U.S. This is largely unprecedented. And then just going back to a point that Mike made, which I thought was a really good one, which is that, there is a conflict between strict letter of the law analyses and practical approaches. And so, U.S. financial institutions have, over the past 10 years paid enormous fines. And so while they might be legally able to engage in certain transactions, they are all taking a step away from the line. And so, U.S. sanctions laws are often, purposely gray or ambiguous. But in this case, the laws are really quite clear. The line is quite clear. But I think that something to look out for is, to what extent will the big operators in the economy, whether it's the big energy companies, financial institutions, et cetera, take a couple steps away from the line, even if they're legally allowed to do something. That's something we're watching closely.
Right. Thank you, Mike. From you, any final?
I think it's been very well covered. I did see the email there about from Dolores about whether she felt that a vessel with a Russian master wouldn't be impacted. I think I have to say that piece of legislation I thought was quite poorly drafted, if that's what you call it. I thought it was rather somewhat reactionary to a story in the Orkney Daily Press or wherever it originally came from. And unfortunately, we've actually seen as an industry very, very broad interpretation of that. If you want, the most extreme one I saw was a British port refusing access to a vessel that had a Norwegian crew manager's office based in Russia. I kid you not, it's been that broadly interpreted. Right. Now that we're all shaking our heads. I can see Julian very vigorously there. Is plainly wrong, but it sort of illustrates the point that I made, and that you just picked up there, Andrew, which is that actually it's so much of this is about attitude, and we've had LNG vessels being turned away because the dockers, which are not Russian, they've got Russian gas on, but they're Greek vessels because it's Russian gas, and the stevedores are refusing to handle the cargo. If it's stevedores that handle gas cargoes, I'm sure what the description is. And I think that's a big problem for us all in the industry. Is actually a very sizable part of the world economy is being taken out, and people simply don't want to deal with it.
Yeah. Yes. All right, ladies and gentlemen. Well, I think on that note, we will wrap it up. Thank you very much indeed to everybody. Thanks to you for joining. Thanks to Maritime London for doing this with Ince, and wish you all a great rest of your day or evening or afternoon. So Thanks, and see you next time.
Thank you.
Bye all. Thank you.